Welcome to the Probate Nation. My name is Richard Ruddy and I'm your host this evening. Probate is a process to transfer the title or ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In order to start the probate journey, someone needs to be in charge of driving the probate train. The title conferred on that person is typically executor or administrator, and they may be named in a will or volunteer to serve if there is no will. Regardless, that person is not empowered to drive the probate train until they are legally appointed to do so. Today we will learn from an expert the nuts and bolts involved in probating an estate in the state of Maryland, with a focus on the oversight role of the local register of wills throughout this probate train ride, from the time you are legally qualified to act to when you wrap up the estate and distribute all the assets to the beneficiaries. With me today is a partner in the Rockville law firm of Joseph Greenwald and Lake. He earned his BA from the University of Chicago and his JD from the University of Colorado School of Law. His practice focuses on estate planning, administration, and taxation issues, and he has more than 20 years of experience helping families through the Maryland probate process. Please welcome Attorney Paul Rikoff. Hi, Paul.
Hi, Richard. How are you today?
Great. Thanks for coming by and talking with us.
Happy to be here.
Well, we're going to talk about probate. There's a lot here to talk about. In Maryland, we've done a number of shows about Virginia probate, but now we're going to talk about Maryland, and much to talk about here. So let's talk about probate. What assets actually get probated?
Well, the assets that get probated are those that can't otherwise transmit themselves to the beneficiaries of a person's estate. So they're assets that are in the individual's name alone. For instance, don't typically have beneficiary designation clauses or any sort of joint titling.
Okay. And now, so what assets do not get probated would be those that are titled maybe jointly or beneficiary designations?
Jointly titled, with beneficiary designations, assets that may be held in a trust that will take them outside of the probate process, and they'll be governed by the trust procedures and the language therein. Okay.
So typical assets like that would be like a life insurance policy often has a beneficiary or a retirement account.
Correct.
Maybe some joint accounts that husband and wife might have held together.
Yeah, or the family home is oftentimes jointly held and transfers on the death of the first spouse outside of probate.
Sure. It's that second death when we get involved with probate.
That's right.
So why is probate necessary?
Well, it's necessary to make valid a will. So a person does a will during their lifetime, but someone has to determine whether that's actually valid and going to govern their estate. So that process does that. It appoints a person to serve as personal representative in Maryland, referred to as executor or executrix in Virginia, but in Maryland they're referred to by personal representative. And so that process is given the bona fides to be able to go out and handle the estate matter during the probate process. It allows creditors to come forward and make claims against the estate, and it handles the administrative side to make sure the assets go, as you said, on that train ride from point A to point B with everybody getting taken care of in between, and then ultimately the assets being distributed to the beneficiaries.
So it is a process to get us from A to B to Z to the end of the road. Well, let's talk about the role in Maryland of the Register of Wills. Give us a little background about what this office does and how it's involved with Maryland probate.
Sure. The Register of Wills is an elected official in Maryland, and there's one for each jurisdiction, which are generally counties in Maryland, but Baltimore City is its own jurisdiction. So there's a Register of Wills elected by the populace of those areas to govern the office of the Register of Wills. The office itself handles all the administrative aspects of probate. So that's where petitions for probate are filed. They're the office that issue letter of administrations to the personal representatives. They take in all sorts of reporting related to the assets of the estate and ultimately the final accounting. So it's a very important role, but they also serve as the clerk of the court for any matter that ends up being judicially administered or that has any hearings related to it or needs other court orders. Okay, so they have a big job. Now, I know that you shared with us the Register of Wills prepared a document called a Basic Instructional Guide for Administering Estates in Maryland, and we're going to show
the cover page online, and we'll post this to our website. But this is quite a very important tool that really talks about the whole process of probate in Maryland. Do you find this very helpful for folks?
I do. It's a good guide to the process. It provides a lot of definitions for terms that people don't encounter in their everyday lives, so I think it's very useful.
Good. Let's talk about what types of estates are actually probated in Maryland. I know we've talked about different things, but let's talk about the two sort of less common ones that you've mentioned to me. One is a modified estate, then there's a small estate, and then there's what you call the regular estate.
Correct.
Talk about what do those all mean?
Sure. Well, a small estate in Maryland is any estate that's $50,000 or less, unless the beneficiaries are, or the beneficiary is only the surviving spouse of the decedent, in which case it can be up to $100,000 worth of assets. When a small estate is available to someone, it allows for very truncated procedures for probate. So there's very little that has to be done in terms of carrying out the probate, and that train ride that you were mentioning earlier is much, much shorter.
Now when you say the 100,000 or 50,000, we're talking about, again, coming back and identifying probate assets.
Probate assets only.
Assets move outside by beneficiaries or whatever, that's not part of that calculation. So it's just those assets are solely in the name of the decedent.
Correct, and it's the net assets too. So if there's debt that's involved, it's netted against that. Okay,
good to know. Well, what about the modified estate?
So the modified estate is a streamlined procedure available to regular estates when they meet certain requirements. They have to be solvent. The assets can only pass to either the personal representative or to a class of beneficiaries that is free from the Maryland inheritance tax, which I know we're going to talk about a little bit later. But basically that means people who are very closely related to the person who passed away. And it can be elected by the personal representative within 3 months of opening the estate. And if the personal representative makes that election, the beneficiaries also have to consent to it. To go by this modified, less stringent process, everyone has to be in agreement. If that's elected, everyone consents to it, then you have to, instead of filing inventory and accountings, which we'll talk about in a moment, there's a final report that has to be filed within 10 months of the administration process, and the assets need to be distributed within 12 months. So it's a process that's available to some states, not right for all states, and it's not so commonly used in our experience, at least in our practice.
So the one that you see the most often, though, is the last one, which is the regular estate. To talk about that for a couple minutes.
Correct. Yeah, the regular estate is any estate, again, that is greater than $50,000 or $100,000 if everything goes to the surviving spouse. And of course, it can go all the way up to the highest number that you can think of in terms of asset value. Once you're in the regular estate train, that has certain requirements associated with it. The first is that you have to file an inventory within 3 months of the probate proceeding being opened, and then you're going to have to file accountings periodically during the course of the probate process. All of those go into the Register of Wills office, and in that office they are audited and reviewed by the audit department of the Register of Wills. And if they find them acceptable, they will issue a report in that regard and send them up to a judge, who then would sign off and approve the accounting. Okay.
So let's talk about how we're going to go ahead and continue our discussion about regular estates and kind of start from the beginning. What's the process to get qualified?
Sure. The first thing a person needs to do is fill out a petition for probate, which is available online at the Register of Wills website in their forms section. And in that petition, you tell the register who died, what their date of death was, where they died. You state, of course, whose petition it is, the personal representative who's making the petition. You give them information about whether or not the decedent had a will, to the best of the person's knowledge, and if so, who the witnesses were to the will and what their addresses are. You tell them if, to the best of your knowledge, there are any other proceedings available, or in process related to the decedent. Was the decedent engaged in litigation? Is there any form of dispute or some sort of litigation that the probate estate might need to undertake? There's a place to let them know that. And then you ask for remedies in that, basically to get appointed as personal representative, that the will, if there is one, be admitted to probate.
Now, do you have to go actually to the courthouse and actually appear?
Well, you do if you don't use a lawyer. Someone's going to have to get that in there. You could probably mail it in and have it processed, but I think most people who do it on their own do make an appointment with a deputy register of wills and go down and meet with them personally to go through it. They're very helpful.
How quickly do you normally get an appointment?
It varies by jurisdiction, as you can imagine.
Sure.
So it can be a few days to a week or so in some jurisdictions. However, they don't, not that they prefer this and probably wouldn't necessarily want it to be said, but they're not going to turn anyone away if they show up at the Register of Wills office. They will try to accommodate them if they can.
That's wonderful.
During their day.
That's good. So how do you determine what register's office to go to?
Good question. That is generally determined based upon where the person is domiciled.
Okay.
And domicile is a permanent residence, let's say. It's where all the legal processes related to a person go, where they file their tax returns, where they're registered to vote, where their vehicles are registered, et cetera. You try to determine where that was and then file the probate process there.
Okay.
If they happen not to be a resident of Maryland, or they don't live in Maryland, then it's generally where the asset with the largest value, where it's located at. That's typically what's used.
Okay. So I do all my paperwork, and then I get appointed, and I get what's called letters of administration, and now I've got authority to drive the probate train.
Right.
So at that point then, do I have to give any notices or publish anything?
Yes. So when you complete your petition for probate, there are a couple other things that you need to file along with that. One of which is a completed newspaper notice. It'll get published in the newspaper.
Okay.
And it's completed in certain fashion by the personal representative, and it gets signed by them. It tells who passed away, their date of death, whether they had a will. It states who the personal representative is and what their address is. It states if there's a lawyer involved, who the lawyer is and what the lawyer's address is.
Sure.
And then it will have some blanks for the register to fill in some information. And that information it gives that they're giving are timelines for the rest of the world to take action related to the estate.
So it's important to get those timelines in there.
Very, very much so.
And we're going to come back to that in a second. So we talked about court filings. So we've got our letters of administration, we've given our notices, and we got that moving. I guess does the register actually take care of getting everything published for you?
Yeah, the register publishes it. They will. You submit that to them. They fill in their required part. They sign it, seal it, get it over to the chosen newspaper.
Okay.
And then they have to run it consecutively for 3 weeks. Then there's also another notice that goes out from the registrar's office. They will then send a copy of that along with a letter to the people who are listed on that list of interested persons.
Sure.
So that they're aware of the probate estate, that it's open, what the probate estate number is, and that they're told that they can get additional information from the registrar's office or the personal representative.
Of course. Now, the other filings you started to talk a little bit about, we're in a regular estate now, so we keep our focus on which estate we're in. There are court filings. So you mentioned we have to file an inventory to kind of tell the Register of Wills what we have in the way of assets.
Right.
We have to value the assets. So what value are we looking for there?
Date of death value. So the value as of the decedent's date of death. In many cases, there are assets that a personal representative in Maryland can value themselves, but in others, they need to have a professional appraiser give them an assessment of the fair market value as of the date of death.
Okay. Now, you mentioned that also there's a need to file an information report. What is that? So
that report is also filed at the same time as the inventory, so 3 months from the opening of the probate estate. And the purpose of that report is to ascertain whether there are assets passing outside of the probate estate that may be subject to the inheritance tax in the state of Maryland. That's the primary purpose of it.
So it's really a form to collect tax information.
Yeah, it is by and large. And they also gather some other information about real estate and other jurisdictions, et cetera, that may not apply to see if there are other proceedings that may be going on. But primarily it's for inheritance tax purposes.
Okay. So an accounting. 9 months after we've qualified.
Correct.
You know, we've taken control of the assets, we need to submit an accounting. So that would be for a period of how long?
Well, it's typically from the period of appointment or death, generally. You start with inventory value, and you'll take everything that's occurred in the estate up until the timeline that you file that, which will be as close to your due date as you can get it, and still have reports, you know, bank statements, et cetera, that tell
that
you the
match
values.
up correctly.
That's
Sure.
right.
That makes sense.
So, and the idea is you're supposed to account for every single transaction to the penny. Every, you know, penny earned of interest, to every expense paid, and if there were any distributions made, you need to say what those were, gains and losses from sales, et cetera, and then give an ending value for that accounting period.
Okay, and you have to document all that stuff.
Yes, you do.
Okay. So, so what happens if you don't timely file?
Okay. That varies a little bit by jurisdiction in Maryland, but in essence, they're going to give you a little friendly reminder that you need to file and quickly. And if you don't heed that reminder, you don't get it filed in time or request an extension, then they're going to issue a show cause order that basically asks you to show cause why you shouldn't be removed as personal representative for not complying.
Okay. We talked about the need to verify stuff. So now let's get on to, you know, the probate train ride, you know, is basically a process to reconcile your accountings with the world and then pass what's left over. One of those people that you got to deal with is, of course, this body of people called your creditors.
Correct.
Okay, so talk about how creditors can make claims against an estate.
Okay. In Maryland, most creditors have 6 months from the date of death to file their claim or otherwise serve it. And that's important. A lot of jurisdictions, the timeline doesn't begin to run until probate is opened, but in Maryland, it runs for almost all creditors from the date of death.
Wow.
So even if they don't get the estate open for 3 months, that 6 month period has been running that entire time. So sometimes creditors don't have a whole lot of time to get their act together and get a claim in.
Wow.
But you can file a claim even before probate matter is open. So if a creditor does know, perchance, that a person has passed away, they can file a claim even if there isn't a probate matter open, and the Register of Wills will take it.
Interesting. Okay. So what about a situation where an estate is insolvent?
There's a statute in Maryland that deals with insolvency of an estate, and there's a priority of people to get paid, and a personal representative needs to familiarize themselves with that statute and run down the priorities until the assets are gone.
Okay.
That's basically what you do.
Okay, so we got to make sure we don't, and so if we think we're going to be an insolvent estate, we want to be careful to not pay people that maybe shouldn't be paid until we get the right order of distribution, payments squared away.
Yes.
All right, taxes. You know, everybody hates that word, but the tax man has to be dealt with. So normal tax filings are going to be final income tax returns and fiduciary income tax returns for the estate, which we have talked about in the past. But in Maryland, we also have inheritance tax and estate tax.
Right.
Talk a little bit about those and how they play out.
So the inheritance tax, as I alluded to before, is a tax that's assessed based upon the degree of representation of the person receiving assets from the person who died. And there's a class of people who are exempt from the inheritance tax, very closely related to the person who died. So parents, grandparents, spouse, children, grandchildren, etc., brothers and sisters. Outside of that class, everybody else has to pay a 10% inheritance tax, other than charities, of course, and you don't have to pay it on life insurance proceeds that don't get paid to the estate if they go directly to a person.
Okay. So when you say pay it, though, does the personal representative have to withhold that money and pay it over?
So the way it works for probate assets is that it will get assessed during the accounting process. So as assets are distributed, the tax has to be calculated and paid at that time and accounted for at that time. The Register of Wills, of course, audits that and determines whether they agree with the amount that was paid or not. For non-probate assets, you file a petition to fix inheritance tax. So that is typically done when the information report is filed. You can get extensions as need be sometimes if there are difficult assets to deal with.
Okay. Well, we can't leave the tax filing discussion without talking about the Maryland estate tax. Tell us a little bit about that.
Sure. Maryland has a state-based estate tax that's designed to tax the assets that a decedent held at the time of their death, not just in the probate estate, but no matter how they held it. So whether they pass outside the probate estate, through beneficiary designation, joint ownership, et cetera, they will be looking to tax that. So they have a requirement of filing an estate tax return for decedents who are required to file one. And that means an estate of a decedent who had more than $3 million of assets in their name at the time they died in 2017.
Okay.
But that's a moving target. In 2018, that exemption level is going to rise to $4 million. And in 2019, barring any change in the law, it will recouple with the federal estate tax laws, which are at $5.49 million for an exemption right now, but indexed for inflation.
And that the dollar amount that you mentioned is a gross amount, okay,
Yes.
without deductions for any expenses. So if your gross estate is that value or more, you have to file the return. You may not owe any taxes because of deductions, but you still have to file the return.
That's right.
Okay, let's talk. We're continuing on. We've talked about taking care of the tax man. We're now at the point of the probate train ride where we're going to give the money to the beneficiary. So. Talk a little bit about the process to distribute to beneficiaries from this probate estate.
Okay. So there are a number of considerations in that regard about distribution. The first and foremost in most personal representatives' minds is making sure that they know who they're supposed to distribute to. So making sure all those timelines have run that we talked about earlier in the notice that the Register of Wills gives to the public about contesting a will or challenging a personal representative. They're generally, before they get into too great of distribution pattern, they're going to want that stuff to have been behind them and for the beneficiaries to be locked in stone.
Okay.
So that process will pass, but they're allowed to make partial distributions if they wish, at their own peril prior to that, but many times it's very common that people will do that in small amounts that they're pretty comfortable with, unless, of course, they are anticipating a challenge. So that's the first aspect of distribution. Beyond that, once you've passed that timeline, personal representatives under Maryland law are free to distribute the assets as quickly as they can. But they have to make sure that they're satisfying the claims that have been filed, the tax obligations that have been filed, any other latent issue related to the particular assets themselves that have to be addressed. All of the distributions will be accounted for on the periodic accountings that need to be filed, which again, the first one is 9 months from date of appointment, and then you have to file another account every 6 months thereafter until the probate proceeding is concluded.
Okay. And then, of course, you do your final accounting and work your way through to get that all approved so that you can actually close the books.
Correct.
Okay. So let's talk a little bit about, this seems like really very complicated. Okay. So should a fiduciary hire a lawyer?
I would say at a minimum it's a good idea to at least speak to a lawyer at the outset to make sure you understand what's expected of you, what's required, what you're getting yourself in for, and to put yourself in the best position to carry out those duties. Then you can make a decision as whether you need more help as you go along or not.
And when we say speaking to a lawyer, that does not mean as you're having a beer out in the backyard, over at a barbecue. I mean, to go sit down in someone's office, bring the paperwork in so they can see what you actually hold in the way of assets, and get some advice that's grounded in the facts of your situation.
That's right.
Does that make sense?
Their advice is only going to be as good as the information they have. That's exactly right.
Well, do you have any final thoughts you'd like to share with our viewers about the Maryland probate process, just by way of suggestions and comments?
Sure. Remember that it's supervised. So the Maryland probate process is overseen by the Register of Wills and ultimately the court. So you want to treat the assets as other people's money, even if you may be the sole beneficiary of an estate. There could be creditors that come forward, other challenges to a will or other vehicle that's transmitting documents. So it's always important to treat it as if it belongs to someone else and you're safekeeping it until the court tells you otherwise. Second thing I'd say is keep very good records. All of the filings, the occurrences in a probate estate are chargeable to the personal representative, and they need to be able to demonstrate how they got from A to Z along the course of that train ride. So it's very important to keep good records that you can rely on. You're probably going to have to show many of them to the Register of Wills along the way, but you may also need to be demonstrating that and proving those transactions to the beneficiaries of the estate.
Excellent. Paul, I want to thank you so much for taking the time to come
happy to
over
be
and
here.
visit with us. You know, it's a great public service that you've done, you know, for the citizens of suburban Maryland, and we hope to have you back again in the future.
Great. Thank you, Richard.
You're very welcome. You know, without a doubt, probate can be complicated and confusing. Our guest tonight touched on a litany of steps you would need to take and stops you would need to make in the course of your journey. Of course, the local Register of Wills is where you become authorized to drive your Maryland probate train, and they retain continuing oversight of your probate journey until it is complete. Be sure to check out all the useful guides, forms, and checklists available online, especially the basic instructional guide on administering estates in Maryland that the Register of Wills produced. But more importantly, and we cannot stress this enough, while there is much you may be able to do on your own during the course of your probate journey, there are many steps that require the guidance of an experienced attorney. We strongly recommend that you get that guidance early so that your entire probate train ride goes smoothly. This brings us to the conclusion of our show today. We hope you found it informative. Replays of the show and all shows to date, along with other helpful information, are available on the Probate Nation website. We encourage you to take advantage of this public service resource. On behalf of the Probate Nation, thank you for visiting with us.